I want you to imagine, picture this scenario for a second. You are right in the middle of a massive, high-stakes legal dispute.
Right, the kind that just drags on for months and drains your energy.
You've been fighting this battle forever, and the clock is ticking down to a hard deadline. I mean, you desperately need to submit this crucial witness statement to the court.
Yeah, and if you don't file it, your case is over. It's just done.
Right. But there's a huge problem. It's Friday night, it's after hours, the banks are closed, the law offices are locked up tight, and you literally cannot find a notary public anywhere to, stamp your document and make it an official sworn affidavit.
Which is a complete nightmare.
It's a total nightmare. So what do? Do you just accept defeat because you couldn't find a person with a rubber stamp?
Well, historically, yes. I mean, it's a situation that has caused genuine panic for people navigating the legal system for, well, centuries.
Centuries, wow.
Yeah, because for the longest time, the law has been entirely tethered to that physical stamp. We have this deep-seated reliance on the ceremony of it all.
No, totally. The raised seal on the paper, the physical presence of a state official.
Exactly. Watching you sign it, the literal raising of your right hand. We demand that ritual because it feels secure, it feels real.
But looking through the sources we gathered for this deep dive, it turns out there is a legal trapdoor. There's an actual way around the notary requirement, but it comes with incredibly high stakes.
Very high stakes.
Yeah.
And it's easily messed up.
Right. So our mission today is to pull apart the mechanics of what the legal system calls an unsworn declaration.
Which is a fascinating little piece of the law.
It really is. We're going to explore why getting just a few seemingly minor words wrong can completely destroy years of litigation. We're pulling from federal statutes, recent state legislation in places like Wisconsin and Texas, a pretty gripping 2007 workplace discrimination lawsuit, and even technical white papers on electronic signatures.
It's a great mix of sources.
Yeah, we're basically looking at how this ancient concept of swearing an oath is somehow surviving in an era of unbreakable digital tracking. It's this wild collision of rigid legal traditions and the need for actual real-world efficiency.
It really is wild.
Yeah.
Because to understand how we actually bypass the notary, we have to look at a specific mechanism that's built into federal law.
Okay, lay it on us.
It's known as 28 U.S.C. Section 1746. So traditionally, courts wouldn't even look at your evidence unless it was a formalized affidavit.
And an affidavit strictly requires a notary, right?
Correct. But Section 1746, it was created as this sort of pressure valve. The government basically admitted that, hey, demanding a notary for every single piece of paper creates an unreasonable bottleneck.
Right, it just slows everything down to a crawl.
Exactly. So this statute allows an unsworn declaration to have the exact same legal weight as a notarized affidavit.
Okay, but, I mean, they don't just let anyone write whatever they want on a napkin and hand it to a federal judge. There have to be rules.
Oh, there are. No, not at all. The entire power of that federal statute hinges on one massive caveat. You have to use incredibly specific mandatory language.
The magic words.
The magic words. If you are signing a document inside the United States, the statute dictates that you must write, and I quote, "I declare under penalty of perjury that the foregoing is true and correct."
I declare under penalty of perjury that the foregoing is true and correct. Just like that.
Just like that. I mean, you can use slight variations like certify or state instead of declare, but you absolutely must explicitly invoke the penalty of perjury.
Wow. So once you type those words, sign it, and date it, that specific phrasing legally replaces the notary stamp.
It does. It completely takes the place of the notary.
It's basically a magic spell. I mean, you recite the exact words and the bureaucratic doors just open for you. And looking at the state-level legislation in our sources, it seems like local governments are aggressively adopting this exact same mechanism.
Yeah, they really are. States see the value in this.
Right. Like in March of 2024, Wisconsin just passed the Uniform Unsworn Declarations Act. I think they call it Act 245. And the reasoning behind it was entirely focused on, leveling the playing field for everyday people.
Yeah, the Wisconsin legislation is a prime example of viewing this whole thing through the lens of access to justice.
Access to justice. I like that.
Because the Wisconsin Judicial Council, they basically acknowledged that forcing people to find and pay for a notary didn't actually make the evidence any more reliable.
Right. It just proves you have $10 and a car to drive to the bank.
Exactly. It just made the legal system harder to access, particularly for pro se litigants.
And pro se, that's people who are forced to represent themselves in court because they can't afford a lawyer, right?
That's right. If you're working a double shift and trying to manage your own divorce or small claims case, you just don't have the time to track down a notary during normal business hours.
Yeah, that makes total sense. And Texas and Florida are doing the exact same thing. In Texas, our sources highlight how private investigation firms, there's one called PRO Tech that they mention, they rely heavily on these declarations to just do their day-to-day jobs.
Well, yeah, because in a private investigation, speed is everything.
Exactly. Like, if you are dealing with vulnerable people, say you're trying to secure a protective order using a Jane Doe pseudonym to keep someone safe.
You have to move fast.
Right. Or if you just need to lock down a witness's memory of a car accident before it fades. You can't always drag them to a UPS store or a bank branch to find a notary.
No, you can't. So the investigator can just sit in their living room, have them write out what happened, sign the magic words, and boom, it holds up in a court of law.
It honestly feels like a legal fast pass at a theme park. You get to skip the terrible line.
It is a fast pass, provided you follow the rules. Because, a fast pass doesn't work if you try to use it at the wrong ride.
Right. And that's where I keep getting stuck when reading through these sources. It is a brilliant, highly efficient tool, and the instructions are literally printed right there in the federal statute. Just copy the sentence. So how do seasoned legal professionals manage to mess this up so terribly?
They assume their good intentions matter more than the rigid text of the law.
Oh, boy.
Yeah. Let's look at the 2007 case of Trapaga versus Central States Joint Board Local 10. This is perhaps one of those painful demonstrations in our sources of how a tiny linguistic pivot can just collapse an entire lawsuit.
This case, reading about it, it is just a masterclass in self-inflicted wounds.
It really is. So the setup involves three factory workers, Oscar Trapaga, Jose Lopez, and Mark Vasquez. They filed a lawsuit against their union, alleging national origin discrimination.
Okay, so a serious, heavy case.
Very serious. This was a massive, multi-year battle, and they'd finally hit a critical juncture called summary judgment.
And just for our listeners, summary judgment, that's the moment in a lawsuit where the defense basically asks the judge to throw the entire case in the trash before it ever gets to a jury, right?
Exactly. It's do or die. To survive that moment, the plaintiff's lawyer had to submit hard evidence, specifically witness declarations, proving there was a real factual dispute that a jury actually needed to hear.
Right. So the lawyer submits 10 of these unsworn declarations to save the case.
He does. But the lawyer made a fatal assumption about his clients. These factory workers primarily spoke Spanish.
Okay.
And the lawyer unilaterally decided that the legal concept of perjury was simply too technical for his non-English speaking clients to grasp.
Okay, I have to stop right there and push back on that lawyer's logic. I mean, if you are a licensed attorney representing Spanish-speaking clients in federal court, you don't just decide to edit a federal statute because translation is hard.
You absolutely do not.
Right. Like, why wouldn't he just take 5 minutes to sit down with them and explain what the word perjury means in their native language?
Well, that is precisely the failure of professional responsibility that doomed the case. Instead of doing the hard work of translating a complex legal concept, the lawyer arrogantly decided he could just write a better law.
Wow.
Yeah. Instead of using the required Section 1746 phrase, under penalty of perjury, he invented his own watered-down phrases.
Oh, no. What did he write?
He drafted declarations that said things like, under penalty of the law requires everyone to tell the truth.
What? That's not even grammatically correct.
Right. Or he just write under penalties of the law.
Which sounds completely meaningless when you actually say it out loud. Penalties of the law.
And Judge Rebecca Pallmeyer, the federal judge presiding over the case, completely agreed with you. She struck 4 of those crucial affidavits from the record, rendering them legally invisible.
Just tossed him out.
Just toss them. And the logic she applied is fundamental to how this entire unsworn declaration system works. She explained that an unsworn declaration only has the power of an affidavit if it genuinely exposes the person signing it to federal perjury charges.
It has to have teeth.
It must have teeth. The phrase, under penalty of perjury, is a specific legal hook. It's essentially a contractual agreement between you and the federal government.
Oh, I see.
Yeah, when you type those words, you are legally consenting to a specific criminal mechanism. If you just wave your hand and say, under penalties of the law, you aren't triggering that mechanism. You're just saying a vague phrase.
Because there's no specific crime called penalties of the law.
Exactly. Because the lawyer softened the language, the judge ruled that his clients were legally immune from federal perjury charges. And if they couldn't be charged with perjury for lying, their statements couldn't be trusted as evidence.
That makes total sense. But the part that makes it so much worse is that the lawyer wasn't just trying to be like, a linguistic pioneer, he was incredibly sloppy.
Oh, incredibly.
The sources detail how he just aggressively copy-pasted translation certificates. Like, he attached Jose Lopez's translation verification to Oscar Trapaga's document.
Yes, a complete mess.
And in one of the verification statements, he actually identified his own client, Oscar Trapaga, as Oscar Lopez.
It just demonstrates how convenience can breed negligence. He literally disarmed the only legal tool that could have saved his clients against summary judgment because he thought close enough was good enough for the federal court system.
It feels like a massive legal double standard, though. I mean, we create this loophole to let people skip the notary because we want the system to be fast and efficient, but then we turn around and throw out years of litigation over a translation choice.
It seems harsh.
It does. But I suppose Judge Pallmeyer's strictness makes sense when you realize that the threat of perjury is literally the only guardrail preventing people from flooding the courts with absolute fiction.
Precisely. Because when you remove the notary, you remove the physical witness to the oath. The only thing left to guarantee the truth is the terror of the consequences.
Right, the teeth. So what are those consequences? We talk about the teeth of perjury, but how does the system actually bite back?
To understand that, we need to look at what legal scholars sometimes refer to as the law of lies. Because there isn't just one type of perjury. There are two distinct federal statutes, and they operate in completely different ways.
Okay, break them down for us.
The first is 18 U.S.C. Section 1621. This covers willful perjury in general proceedings. Now, to convict someone under Section 1621, prosecutors have to prove that a statement is demonstrably false.
Which honestly sounds straightforward until you realize how hard it is to actually prove a lie.
It is incredibly difficult, and largely because Section 1621 is restricted by an ancient concept called the two-witness rule.
Two-witness rule, what's that?
It's a vestige of common law, the deeply historical, precedent-based legal system that predates our modern statutes. The common law tradition demanded that a person could not be convicted of perjury based solely on the word of one other person.
Oh, so it's a he said, she said prevention tool.
Exactly. It basically requires prosecutors to bring independent corroborating evidence to the table. It sets a deliberately massive hurdle for the government to clear.
But you mentioned two statutes, so I assume the second one is a lot easier for the government to use.
Oh, yes. 18 U.S.C. Section 1623 is the prosecutor's trapdoor. This statute applies specifically to statements made in federal courts and grand juries, and it is designed to be a much, much sharper weapon.
How so?
For starters, that archaic two-witness rule is completely eliminated.
Wow, okay.
The government doesn't need that same level of independent corroboration. But the truly terrifying part of Section 1623 is the mechanism of proof. Prosecutors do not even have to prove that a specific statement you made is false.
Wait, what? How can you convict someone of lying without actually proving what the truth is?
Because under Section 1623, the government only needs to prove that you made two statements under oath that are so wildly inconsistent that they cannot logically both be true.
Oh, I get it. So if we look at it like a parent catching a teenager in a lie, you don't necessarily have to prove exactly whose house your teenager was at on Friday night. You just pull up their text messages and show that, hey, at 9:00 p.m. you claimed to be at the library, and at 9:05 p.m. you claimed to be at the movie theater.
Exactly.
You don't know which one is the lie, but you know a contradiction exists, and the contradiction itself is the offense.
That is a perfect synthesis of how the law operates. You don't have to uncover the objective truth. You merely have to expose the impossibility of the two statements existing simultaneously. Now, there's one critical limitation that applies to both of these statutes, though, and that's the concept of materiality. The lie has to actually matter.
Right, like if you are testifying in a corporate fraud case and you lie about what you ate for breakfast, like that's not perjury.
Precisely. A material statement is one that is actually capable of influencing the decision-making body it is addressed to. But when a material lie is caught, the consequences are devastating, regardless of who you are.
Yeah, the sources outline how these statutes have snared massive public figures across all spectrums.
They really have. You have professional athletes like Barry Bonds and Roger Clemens facing severe legal peril over grand jury testimony regarding performance-enhancing drugs.
Oh, yeah, I remember that.
And the Olympic track star Marion Jones was actually convicted and served federal prison time.
And it spans deeply into the political and entertainment worlds too, right? Our sources highlight figures across the board, from political operatives like Scooter Libby being convicted during grand jury investigations, all the way to the rapper Lil' Kim.
Yeah, she served a prison sentence for making false statements to a grand jury. about a shooting.
It's wild. It just illustrates that the phrase penalty of perjury is not just boilerplate legal jargon. It is an active, dangerous threat.
It really is. When you choose to bypass the notary and invoke that phrase, you're literally offering up your personal liberty as collateral for your honesty.
Which brings us to the most modern collision of these ideas. I mean, we've spent this entire deep dive talking about pieces of paper, wet ink, and specific typed phrases. But what happens when we strip the paper out of the equation entirely? Let's talk about the digital frontier, like electronic signatures and the world of DocuSign.
Oh, this is where ancient legal theory meets modern cryptographic reality. It's fascinating. So, to make electronic signatures viable in commerce, the government created legal bridges, specifically the Federal e-Sign Act and state-level adoptions of UEDA.
UEDA, that's the Uniform Electronic Transactions Act, right?
Correct. Before UEDA, if you signed your name on a screen, courts essentially viewed it as a meaningless digital drawing. It meant nothing. UEDA and the e-Sign Act were the frameworks that dictated an electronic signature must be given the exact same legal weight as pen and ink.
But looking at the sources, it shows that an electronic signature is actually far more dangerous than a physical one, because with paper, you just have the ink. With software, you have an omniscient digital witness watching you.
You are referring to the audit trail. And yes, it is a prosecutor's dream. Let's examine the 2018 case of I.O. Moonwalkers versus Bank of America Merchant Services.
Sounds like a sci-fi movie.
Right, so this was a dispute over business banking services. The CEO of I.O. Moonwalkers tried to weaponize the digital nature of the contract. He claimed he never actually signed the agreement.
Oh, the classic, it wasn't me defense.
Exactly. Now, in a traditional paper world, that denial creates a massive logistical headache. It requires bringing in handwriting analysts, debating who had access to the paper, and just endlessly litigating a factual dispute.
But the bank didn't need a handwriting expert here. They just pulled the DocuSign audit trail.
And the audit trail is merciless. The court looked at the metadata attached to the digital signature. It logged the exact date, the precise time down to the second, and the specific IP address of the device used to access the document.
Wow.
Yeah. And that IP was routed directly through the CEO's own corporate email infrastructure. It provided an undeniable cryptographic timeline, proving he reviewed and ratified the agreement. The court granted summary judgment against him almost instantly.
I mean, the machine provides a level of certainty that a human notary never could.
We see that certainty applied again in a bankruptcy case called In re Henriquez. A debtor attempted to argue he didn't intend to be bound by a loan modification agreement that he had electronically signed. He tried to argue it was just a draft or, a mistake.
But I'm guessing the metadata said otherwise.
Oh, it did. The court utilized the digital audit trail to map his exact behavior within the software. The metadata proved precisely when he opened the file and confirmed that he had intentionally applied his digital initials to every single page. You cannot accidentally initial 40 pages of a contract.
Right. So technology provides this unbreakable chain of evidence. But here's the massive caveat that genuinely surprised me in the research. Technology cannot save you from bad lawyering.
No, it cannot.
Let's look at the 2018 case of Thomas v. Credit Management, LP.
This case perfectly encapsulates the tension between digital efficiency and statutory rigidity.
Yeah. In this case, you have an electronically signed declaration. It possesses a flawless, unbreakable digital audit trail. The metadata proves beyond a shadow of a doubt exactly who signed it, the second they signed it, and the computer they were sitting at.
Right.
It is, technologically speaking, the most perfect piece of evidence imaginable. But the court threw it out in the trash anyway. Why?
Because the digital document lacked those 5 magic words. The electronic file did not contain the phrase, "under penalty of perjury."
Unbelievable.
Lawyers assumed the sheer technological weight of the audit trail was enough. But the court ruled that while metadata perfectly proves the timing and the identity of the signature, it completely fails to fulfill the statutory requirement of 28 U.S.C. Section 1746.
That is wildly ironic. I mean, you can have an unbreakable cryptographic system tracking every digital footstep you take, but a federal judge will still throw your perfect evidence out the window if you forgot to type the specific words required by a law written before the internet even existed.
It proves that technology is merely a delivery mechanism. It does not overwrite the underlying legal requirements. And there is one final critical warning in our sources regarding this digital frontier.
Oh, what's that?
It's highlighted by a 2016 bankruptcy case, Henry Mayfield. A lawyer submitted a set of documents to the court using software-generated electronic signatures. He assumed that because the federal e-sign Act protects digital signatures in commerce, he was fully protected. But the bankruptcy judge actively penalized the lawyer for doing this.
Wait. How can a local bankruptcy judge overrule a massive federal statute like the E-Sign Act?
By understanding the difference between commerce and procedure.
Oh, interesting.
Yeah. The e-sign Act governs commercial transactions and contract law. But judges control the procedure inside their own courtrooms. They establish local rules to prevent fraud and manage the flow of evidence.
So the local rules trumped the federal act.
In this specific venue, yes. The local court rules explicitly insisted that attorneys must maintain the original, physically signed paper documents with wet ink. The judge ruled that federal statutes designed to help banks process loans do not override a local court's procedural rule demanding a physical piece of paper.
So you can have the full weight of the federal government declaring that electronic signatures are valid, but if the local judge's procedural rulebook says they want to see blue ink on a white piece of paper, you had better have a real piece of paper.
Exactly. It requires practitioners to have a dual awareness. You have to deeply understand the modern technology you're utilizing, but you also have to navigate the hyper-specific, sometimes aggressively archaic, procedural rules of the specific room you are standing in. You can never, ever assume that digital convenience will magically override judicial procedure.
Man. So if you are listening to this and wondering how this all applies to you, what is the ultimate takeaway? The truth is, you possess an incredible tool to bypass bureaucratic red tape. The Unsworn Declaration is a mechanism of tremendous speed.
It absolutely is.
Whether you are a private investigator trying to lock down a fleeting memory or a pro se litigant fighting for your rights at midnight without a budget for notary fees, you have access to a legal fast pass. But the power of that tool is entirely 100% dependent on respecting the exact phrasing demanded by the law.
You cannot water it down to make it sound friendlier.
No.
You cannot rely on DocuSign metadata to save you. You must use the magic words.
Under penalty of perjury. And as we conclude, I want to step back and leave you with a larger philosophical question to consider. We are plunging headfirst into an era defined by deepfakes, AI-generated content, and incredibly sophisticated digital manipulation.
We really are. It's moving so fast.
We are rapidly approaching a societal tipping point where video evidence, audio recordings, and even cryptographic metadata might be fundamentally questioned by juries who have learned they can no longer trust what they see on a screen.
It is a terrifying reality to face in a courtroom. If you can't trust the video, what can you trust?
That is exactly the point. Could it be that the most ironclad, legally binding anchor of truth left in our entire justice system won't be technological at all? What if, when all the digital systems fail to guarantee reality, the ultimate proof of truth relies entirely on the ancient, solemn, fundamentally human act of typing the words under penalty of perjury?
It's a powerful thought. It is a promise that stakes your very freedom, your personal liberty on your honesty.
And to think, all of that weight, all of that immense power to bind human truth is sitting right there, available to you at 11:00 p.m. on a Friday night when every notary in the city has gone home. You just have to be brave enough and precise enough to use the spell.